of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, Subarticle 6, which obligates this Honorable Senate to accord the Deputy President an opportunity to be heard. So I do leave the matter in your hands, Mr. Mheshimiwa Speaker and Honorable Senators. I would suggest Article 145, the subarticle I've read, subarticle 6B, doesn't have a time limit of 10 days. Give the Deputy President, in the interest of justice, given the weight of removing a Deputy President from office, give him a couple of days. I thank you.
So if I get you correctly, Senior Counsel Paul Mwite, it is your application to the Senate that your client be given a couple of days. Now, a couple of days doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days ahead in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, permit me to start by registering our greatest sympathies and empathies, and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned Senior Counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency the Deputy President has participated robustly in the proceedings both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Before the National Assembly, His Excellency the President did file a response dated the 8th of October 2024. When the proceedings before this House began, His Excellency the President, the Deputy President again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point in time, His Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency the President would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, having also very keenly heard learned senior counsel speak, matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, sir, matters held cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that we'll be able to proceed on that assigned day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I'd earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral, we have had practice in our Supreme Court where dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency, the Deputy President, has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forego the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency the deputy president. Mr. Speaker, sir, we urge that if I heard my learned senior colleague, Mr. Paul Mwite, senior counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions. I'm most obliged.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, Subarticle 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, they must be a safety valve. Article 145, Subarticle 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the deputy president, states as follows. The president, and for that matter, it should be read, the deputy president, shall they have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the deputy president can elect to be represented either by his advocate or by him appearing in person, or having both the deputy president and his advocate to appear. Now, I want to put before the Senate, because a lot of you have this problem a lot of time during the elections. If, in accordance with the election law, you are required to subscribe your nomination papers on a certain day, and you fail it, you're running for president or deputy president, and you're told that you must present your nomination papers on a certain day, as it is there in the law, would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you an accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this Senate very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us where, or if he has told us, the medical institution where the deputy president is. But for the deputy president to fail to bring evidence, credible evidence before the House that has been admitted, even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented in medical documents, and later on they've been found to be fake, if I may use that word. I think that the deputy president should have done, we should have had one of the doctors here, at least to tell us about his admission and about his condition, because up to 1:15, the deputy president was here. He was not evacuated from here in an ambulance. And if I can give evidence from the bar, he went to his office, and again, there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the deputy president. But unfortunately, the story that has been told does not include cross-examination of the evidence of the deputy president, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us. The sickness of the deputy president is affecting us more because we would want to cross-examine him. But he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the deputy president would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the deputy president is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without no documentary proof of where the deputy president is and what ailments is suffering for? I think the more important duty for this Senate is to comply with the Constitution. And we urge you to comply with the Constitution and proceed with the hearing of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, honorable senators, we all live in Kenya, and I would like to make this submission. These gadgets we have here capture every word uttered accurately. so that if I was found tomorrow to have lied to these senators, sanctions can be brought on me. And I would have thought that that fear of telling a lie to this honorable Senate, to me, is more powerful than even bringing a medical report. We've had many medical reports generated outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there when I was asking to be given up to 5 p.m. And it was a rush. Was I to fail to come back to this honorable house at 5 p.m., waiting for a medical report when the doctors there are busy attending to their patient, the deputy president? Medical reports I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning, they are seated down when he's giving evidence from the bar about some cases filed in Malindi that I'm not aware of. Perhaps he should have given us a copy of that. Mheshimiwa Speaker, Article 145, Sub-Article 6 is clear, and I do not want to take time of this august House, Senate. Going back to it, it applies, and I would plead with you and with honorable senators to give us until Tuesday to see whether the deputy president will be well enough. No one decides when to get sick and when not to get sick. I am sure many honorable senators here will have a story of their shock because of having spent an evening with somebody, then the following day they hear that the person is gone. Yet that person was looking good and healthy. Let's be humane. Let's be compassionate. Tuwe na utu kidogo. Tuesday, the heavens are not falling down to join with the earth. I thank you, Mheshimiwa Speaker.
Senior Counsel, Paul Mwite. There is a hypothetical question that was raised by Senior Counsel Orengo. Assuming, and it's just an assumption, assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this honorable House, honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable senators seeing with their own eyes how a witness withstands cross-examination. There are many times when different impressions will be given by a written document, and yet when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there's nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The deputy president wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the deputy president we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the deputy president back in place so that he can be here on Tuesday, Mr. Speaker. If he's not here, let that decision of what this honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the deputy president, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of the Senate, where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly, also through its legal counsel, has also told the Senate that it is willing to forego the cross-examination of the Deputy President, who was to appear as the sole witness in this historic trial in the Senate. The National Assembly did forward to this House 11 grounds of impeachment, which it believes that it has presented enough evidence to warrant the impeachment of the Deputy President. Among the grounds that the National Assembly did advance is the gross violation of Article 10, Sub-Article 2A of the Constitution, and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and Article 2B of the Constitution. The National Assembly, in its submission during this trial, did say that the matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic of Kenya, is required to promote constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy, and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized, and good governance. It will also respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources, and to promote and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language, or birth. In its argument, the National Assembly said that on diverse dates throughout the last 2 years, His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. In forwarding its evidence to the Senate for the purpose of this trial, the National Assembly did illustrate instances where it believes the deputy president, has been on record committing the said violations. Ground 2, gross violation of Article 147, Sub-Article 1, and Article 152, Sub-Article 1 of the Constitution. The National Assembly states that Article 147, Sub-Article 1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152, Sub-Article 1 of the Constitution states that the Deputy President is a member of the Cabinet. The National Assembly argues that on various dates throughout the last 2 years, His Excellency, the Deputy President, undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. Under this charge, the National Assembly has moved to illustrate instances and occasions in which it deems the Deputy President to have committed this offense. That on or around 30th of April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. Shortly after that, His Excellency the Deputy President made a public statement opposing the Nairobi River riparian evacuation orders, which the National Assembly argues that the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency the Deputy President made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, the National Assembly argues that His Excellency the Deputy President has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. It has also tried to illustrate that in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency the Deputy President, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. That His Excellency the Deputy President has made numerous other utterances at public forums where he publicly restates the division narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general election. The National Assembly argues that the Deputy President's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that they undermine the effective discharge of the national government's executive mandate, that they violate the doctrine of collective responsibility, and that they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the 4th Schedule to the Constitution. This, quote-unquote, undermining devolution. The National Assembly, in its submission in this trial, argues that Article 10, Subarticle 2A of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6, Subarticle 2 of the Constitution provides that government at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions, the National Assembly argues, that are supplemented by Article 189, Sub-Article 1 of the Constitution, which provides that governments at each level shall perform and exercise their powers in a matter that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of part 2 of the 4th schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, which the National Assembly argues is an essential organ for consultation between the two levels of government. In its submission before the Senate, the National Assembly, through its legal representatives, say that on or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and the location of markets. Further, the National Assembly argues that His Excellency, the Deputy President, publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, the Deputy President has interfered with the proper discharge of county government's constitutional functions regarding alcohol and control and regulations. His Excellency, the Deputy President's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution. This is according to the submission by the National Assembly, and that they undercut the functional and institutional integrity of county governments. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua, according to the National Assembly, has grossly violated Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, and Article 189, Sub-Article 1 of the Constitution, as read with the 4th schedule to the Constitution. Ground 4, the National Assembly accuses the Deputy President of gross violation of Article 160, Sub-Article 1 of the Constitution, which talks about the undermining of institutional and decisional independence of judges. In its submission, the National Assembly argues that Article 160, Sub-Article 1 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Sub-Article 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offenses to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his account. The team argued that this Senate can make a decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we are waiting for the Speaker to make a ruling on this request.
Urerorera Captain TV. Nemothia wa wiki.
Article 5A of the Constitution, which talks about the breach of the oath of office and allegiance. The National Assembly, in impeaching the Deputy President, argued that His Excellency Rigathi Gachagua's actions and utterances outlined in Ground 1, 2, 3, and 4 constitute a gross violation of Article 3, Sub-Article 1 of the Constitution, which requires every person to respect, uphold, and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148, Sub-Article 5A of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President that obligates the Deputy President to obey, preserve, protect, and defend the Constitution. There's also serious reasons, according to the National Assembly, to believe that the Deputy President has committed a crime under national law pursuant to Article 150, Sub-Article 1B, Part 2 of the Constitution. Under Ground 6, the National Assembly, in its submission, argues that there's serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13, Subsection 1A, and Section 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when having regard to all the circumstances ethnic hatred is likely to be stirred up. The National Assembly argues that besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, according to the National Assembly, details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13, subsection 1, and Section 62 of the National Cohesion and Integration Act. Ground 7. Serious reasons to believe that His Excellency Rigathi Gachagua has committed crime under Sections 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency the Deputy President has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired, according to the National Assembly, over the last 2 years is incompatible with his non-legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, or Kevin Gachagua, and Keith Ikenu Rigathi, and other close family members and associates as proxies. The National Assembly argues that His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used a number of companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Anytime from now, we will hand you over to the live proceedings of the Senate, where we do expect in a couple of moments the Speaker of the Senate will walk into the chambers to deliver that much awaited ruling on the way forward. The senators are making their way into the chamber, taking their seats, signaling probably the imminent arrival of the Speaker of the Senate. Just a quick recap. The Speaker adjourned the sitting briefly to draft a ruling on the request by the senior counsel Paul Muite, representing the Deputy President in this historic trial. The senior counsel told the Senate that the Deputy President had fallen ill and he had been in contact with his doctors at the current hospital, and he also did indicate that he didn't speak directly to the Deputy President on orders by the doctors who are continuing to examine the Deputy President. And in response, the National Assembly, through its legal team, argued that they do not need to cross-examine the Deputy President, who was scheduled to take to the witness stand. But the Senate should consider using the evidence presented by the Deputy President in his submission to make a decision. The National Assembly, through its legal representatives, argued that the matter before the Senate has strict timelines, and so it should be dispensed with. And that is the decision that we are now waiting for the Speaker to make. Ground 8 is serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. That His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The National Assembly has illustrated in its submission to this trial that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly, according to the National Assembly, said he would present a petition for the removal of the said judge, which he has not done to date. But this was amended during cross-examination yesterday of the mover of this motion, Honorable Ekamas Mwengi Mutuse, who said that he has been made aware that the Deputy President has indeed presented a petition for the removal of the said judge. There on your screen is the clerk of the Senate. And now we await for the arrival of the Speaker of the Senate. Currently, the bell is being rung, and we now await the arrival of the Speaker. Ground 9. And there is the Speaker of the Senate, who is now walking into the chambers. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly, when asked to comment on the circumstances, argued that unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that pursuant to Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, the proceedings proceed. Now I'll read Rule 11. It provides thus: where the National Assembly or the Deputy President chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, it is also noteworthy that Rule 12 provides as follows. Subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him. Senior Counsel then proceeded to cite Article 145(6), observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145(6) provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145(6)(b) of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145(6) of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145(3) of the Constitution. Counsel observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Counsel therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Counsel then indicated that if any prejudice was to be suffered, by the failure of the Deputy President to testify and be cross-examined, this will be on the part of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Counsel then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Counsel argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forego the cross-examination of the Deputy President and requested that both parties be allowed to highlight the submissions during their closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) of the Constitution, arguing that the right to appear and be represented include the right to be represented by counsel. He argued that the Senate that the greater duty was to comply with the Constitution, and that the Senate could not accordingly go outside the timelines as set out in the Constitution. It is noted that the present hearing was convened via Gazette Notice 163, Volume CXXV1, dated the 9th of October 2024. Via that Gazette Notice, I appointed Wednesday, 16th October 2024 as the date for the commencement of the hearing, and further that the hearing will run up to the conclusion of the hearing on Thursday, the 17th of October 2024. As presently convened, therefore, today at midnight, unless midnight finds the Senate in the course of division, marks the end of the period for the hearing of the present impeachment matter. As this process is time-bound by the Constitution to be concluded in not more than 10 days, pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday, the 19th of October 2024, the only window open to the Senate, if it so obliged the request for adjournment sought by counsel for the Deputy President, will be to gazette Saturday, the 19th of October 2024 as a further and final day for hearing of this matter. Now, honorable senators, ladies and gentlemen, such a request is not made to the Speaker, but to the Senate, and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday, the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter, this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. Needless to say, if the motion is not carried, the decision of the Senate will be that this hearing continues to conclusion in the manner provided for under Rule 12. In such event, the hearing will continue as set out in the program, with the parties moving to make their closing statements. Now, honorable senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and best wishes for a quick recovery to His Excellency Rigathi Gachagua, AGH, the Deputy President of the Republic of Kenya. Next to the clerk. Now, honorable senators, you have been circulated with the supplementary order paper. That is the order paper that we are going to use from now going forward. Clerk, now, honorable senators, this being a procedural motion, you don't need to give notice. So when the order is read out, the majority leader will be called upon to move. Clerk, call the order, please. Honorable Senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the ground specified in the motion. Whereas by letter reference NA/DLP/TBO/MTS/2024-025, dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas vide Kenya Gazette number 137/18, volume CXX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, and Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1, to adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)C of the Senate Standing Orders, to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day. In order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. Hatuwezi sisi tukasema kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole. Senate imempatia pole na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate, kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Now, honorable senators, I'll proceed to propose a question, which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DL/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145 as read with Article 151(b) and 2 of the Constitution, and Standing Order 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Order 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. we rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with the Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into bracket 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon. In which case, then, we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, honorable senators, we shall move to hear the closing statements by Counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Thank you very much, Mr. Speaker, sir. On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, honorable senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But Honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable senators. Senator Fernandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore, it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this House, you need 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion, Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the deputy president, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the deputy president saying that, there's precedent. There is no precedent in our courts in terms of impeachment. There's precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the deputy president first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, it's a strict legal process. You have to show and demonstrate that the deputy president, has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office, of it taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment and 2/3 if it succeeds in this House, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the Deputy President in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the Deputy President suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are 2. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied, the justification cannot stand, and indeed, Mr. Speaker, once one of the senators asked for the justification, and I had the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this August House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was played here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the Deputy President on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruptions. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the Deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outfund, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibits, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision in Asset Recovery Agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the document filed by the Deputy President, there is not a single document that shows that this judgment has been set aside, has been compromised, or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there's good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter they entered some sort of negotiation is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live, and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss, whom he has accused of being behind this motion. He would not actually work with the cabinet, where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage, and I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion The Honorable Rigathi Gachagua is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the Deputy President today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, Honorable Senators, Honorable Speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa muongoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, namwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliwachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa aende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais wametoshea kupewa urithi wao, Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga, mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka stesheni ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema, tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa Deputy President. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular, paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the Deputy President, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would would be sufficient to impeach such a Deputy President. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir. We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media